Hello, I'm Mark Lathem, and I'm a lawyer that practices law in Richmond Hill, Ontario. And over the last 20 years, we've purchased virtually thousands of new homes and condominiums on behalf of our clients. And of course, I'm here to talk about the HST implications of the purchase of a new home and condominium, because most of these are sold as HST included. And of course, there's a bit of a catch with that, and it's not that straightforward. The legislation allows a builder to sell a house to somebody on the assumption, or condominium, on the assumption that that person is moving into it as their principal residence. And because the government wants to encourage people to acquire and pay for their house, they've reduced the HST by an average of 8% on any property below $450,000 or any property over $450,000 by a flat $24,000. So if the buyer does not qualify for this rebate, the builder is obliged to collect the additional amount. Like I said, the rule of thumb is 8% if the purchase price is below $450,000 or a flat $24,000 if it's over. Now, in order to qualify for the rebate, the builder must be selling to somebody who's moving into the property themselves as their principal residence, or has bought the property for the principal residence of an immediate family member. Immediate family member literally means children or parents. Should the person not qualify, then the builder is obliged to collect this additional amount. Now, there's a number of important points about understanding the HST rebate itself. And that is, first, I mentioned principal residence. And in fact, the wording of the legislation is primary residence. And the term primary residence is intended to exclude a discount on what you would call a secondary residence, such as a cottage or a weekend condo in Toronto. So for this type of personal use property, the buyer must pay the HST and is not entitled to any rebate whatsoever. The second is the rental housing rebate. Where the purchaser has purchased the property for the purpose of providing rental housing or increasing the rental housing stock, the purchaser is entitled to a rebate. However, the money must be paid to the builder first, and then the government in effect polices the rebate and requires the buyer to apply to have the exact same amount returned. They require an application to be provided along with certain closing documents and a one-year lease. The CRA's position is that if the person does not retain ownership of the house for at least 1 year following the closing, then they will consider them not to be qualified for the rebate. And the last item I'm going to go over is the flipping of real estate. Essentially, a person who's acquiring the property for flipping, which means they're assigning the property or they're reselling it immediately following closing, or frankly, CRA takes a position, any sale within a year of closing is flipping, then they will be disentitled to the rebate, and CRA will charge them the full amount. A word of caution: many real estate agents advertise the assignment of these purchase and sale agreements, and the problem is that they are subject to HST. And I think the biggest problem is the HST GST rules came out about 1990, just about the time I became a lawyer, and the GST rebates were a very small amount. They often were about 2%, and the PST rebate is 6%, making up that 8% I referred to earlier. And this 8% now means that the policing of the rebates is worthwhile by the government because there's a lot of money at stake. And there's a CRA bulletin that was issued in July of 2011, and this is the example it set out. When I was first a lawyer, before 2000, the assignment contracts were generally drafted by lawyers. After 2000, they became drafted by real estate agents by modifying the existing ORE forms, and ORE forms came out with a particular form of assignment contract. However, the ORE form and the way that real estate agents typically draft assignment contracts bring with them a considerable tax problem that I want to talk about. And that is, if we take a buyer from a builder who wants to assign the contract, who's entered into a purchase agreement for $200,000, they want to sell their contract for $100,000 so that the ultimate buyer, or what's called the assignee, is paying a total cost of $300,000. A lawyer would typically describe this as an assignment contract where the purchase price is $100,000. And this is subject to GST, or HST, sorry. So the amount of HST that would be payable on the $100,000 contract would be exactly $13,000. However, the ORE form that is currently used, and real estate agents will typically choose to list the purchase price as $300,000, which carries with it an HST liability of $36,000. So my recommendation is that you need to consult a lawyer, in particular, who is familiar with assignments and familiar with this specific problem, and have them draft the assignment contract for you or redraft the current ORE form. What I am recommending to people is that they list the purchase price as the amount the buyer or assignor is actually receiving for assigning the contract. So in this example, $100,000, and the contract go on to say that the assignee will ultimately reimburse the buyer for their assignor for their deposits, plus they will pay whatever the balance is still owing to the builder. I'm going to caution everybody that while this is the advice I'm giving, I did not obtain a tax ruling from CRA, although I did place a call, and they seem to indicate that if you're dumb enough to list the purchase price as $300,000 when you could have listed it as $100,000, they're likely going to tax you on the $300,000. So I'm just going to point out that particular issue, and I think the position that $100,000 is the appropriate amount to list as a purchase price is quite frankly defensible and falls in line with the legal practice of years ago. Now, a final note about CRA and enforcement. Because HST has taken, has made the numbers that the government is entitled to at large, CRA is now auditing virtually every HST application that is filed on a new home and condominium. We've discovered, based on our own clients' experience, that they're comparing the information in the application to the client's personal income tax records, the personal income tax records of their spouse, they're checking the land registry office, and they're checking things like driver's licenses. So we're cautioning everybody to be absolutely truthful in their applications to Revenue Canada, because they're, in this case, likely to be caught, number one, and to file the appropriate rebates the appropriate way. I hope that you found this video to be educational, and I would like to close by quoting Susan Elliott in a Law Society video. Susan Elliott was a former head of the Law Society, and she was reminding everybody that when it comes to real estate, the single most experienced person that they are going to deal with of all the parties, such as the real estate agents, mortgage brokers, the bank, is going to be their real estate lawyer. While many of these people do a few deals a month if they're very successful, most lawyers who've chosen to focus their practice on real estate literally do 30 to 60 deals a month. And in my case, which is typical, we have experience at closing over tens of thousands of transactions versus a few hundred transactions. So I'd like to thank you very much for your consideration, and I hope you found this video helpful.